Hudson v. Michigan, Supreme Court, 2006. Justice Scalia delivered the opinion of the court. Suppression of evidence, however, has always been our last resort, not our first impulse. The exclusionary rule generates substantial social costs, which sometimes include setting the guilty free and the dangerous at large. We have therefore been cautious against expanding it, and have repeatedly emphasized that the rule's costly toll upon truth-seeking and law enforcement objectives presents a high obstacle for those urging its application. We have rejected indiscriminate application of the rule and held it to be applicable only where its remedial objectives are thought most efficaciously served, that is, where its deterrence benefits outweigh its substantial social costs. The exclusionary rule has never been applied except where its deterrence benefits outweighs its substantial social costs. The costs here are considerable. In addition to the grave adverse consequence that exclusion of relevant incriminating evidence always entails, the risk of releasing dangerous criminals into society, imposing that massive remedy for a knock-and-announce violation would generate a constant flood of alleged failures to observe the rule. The cost of entering this lottery would be small, but the jackpot enormous. Suppression of all evidence amounting in many cases to a get-out-of-jail-free card. Courts would experience, as never before, the reality that the exclusionary rule frequently requires extensive litigation to determine whether particular evidence must be excluded. Another consequence of the incongruent remedy Hudson proposes would be police officers refraining from timely entry after knocking and announcing. As we have observed, the amount of time they must wait is necessarily uncertain. If the consequences of running afoul of the rule were so massive, officers would be inclined to wait longer than the law requires, producing preventable violence against officers in some cases and the destruction of evidence in many others. We deem these consequences severe enough to produce our unanimous agreement that a mere reasonable suspicion that knocking and announcing under the particular circumstances would be dangerous or futile, or that it would inhibit the effective investigation of the crime, will cause the requirement to yield. Next to these substantial social costs, we must consider the deterrence benefits, existence of which is a necessary condition for exclusion. It is not, of course, a sufficient condition. It does not follow that the Fourth Amendment requires adoption of every proposal that might deter police misconduct. To begin with, the value of deterrence depends upon the strength of the incentive to commit the forbidden act. Viewed from this perspective, deterrence of knock-and-announce violations is not worth a lot. Violation of the warrant requirement sometimes produces incriminating evidence that could not otherwise be obtained. Ignoring knock and announce can realistically be expected to achieve absolutely nothing except the prevention of destruction of evidence and the avoidance of life-threatening resistance by occupants of the premises, dangers which, if there is even reasonable suspicion of their existence, suspend the knock and announce requirement anyway. Massive deterrence is hardly required. It seems to us not even true, as Hudson contends, that without suppression there will be no deterrence of knock and announce violations at all. Of course, even if this assertion were accurate, it would not necessarily justify suppression. Assuming, as the assertion must, that civil suit is not an effective deterrent, one can think of many forms of police misconduct that are similarly undeterred. When, for example, a confessed suspect in the killing of a police officer, arrested, along with incriminating evidence, in a lawful, warranted search, is subjected to the physical abuse at the station house, would it seriously be suggested that the evidence must be excluded, since that is the only effective deterrent? And what, other than civil suit, is the effective deterrent of police violation of an already confessed suspect's Sixth Amendment rights by denying him prompt access to counsel? Many would regard these violated rights as more significant than the right not to be intruded upon in one's nightclothes, and yet nothing but ineffective civil suit is available as a deterrent. And the police incentive for those violations is arguably greater than the incentive for disregarding the knock and announce rule. We cannot assume that exclusion in this context is necessary deterrence simply because we found it was necessary deterrence in different contexts long ago. That would be forcing the public today to pay for the sins and inadequacies of a legal regime that existed almost half a century ago. Dalry map could not turn to 42 U.S.C. 1983 for meaningful relief. Monroe v. Pape, which began the slow but steady expansion of that remedy, was decided the same term as map. It would be another 17 years before Section 1983 remedy was extended to reach the deep pockets of municipalities. Citizens whose Fourth Amendment rights were violated by federal officers could not bring suit until 10 years after MAP, when this court decision in Bivens v. 6 unknown federal narcotics agents. Hudson complains that it would be very hard to find a lawyer to take a case such as this, but 42 U.S.C. Section 1988b answers this objection. Since some civil rights violations would yield damages too small to justify the expense of litigation, Congress has authorized attorney's fees for civil rights plaintiffs. This remedy was unavailable in the heydays of our exclusionary rule jurisprudence because it is tied to the availability of a cause of action. For years after MAP, very few lawyers would even consider representation of persons who had civil rights claims against the police. But now, much has changed. Citizens and lawyers are much more willing to seek relief in the courts for police misconduct. The number of public interest law firms and lawyers who specialize in civil rights grievances has greatly expanded. Hudson points out that few published decisions to date announce huge awards for knock-and-announce violations, but this is an unhelpful statistic. Even if we thought that only large damages would deter police misconduct, and that police somehow are deterred by damages, but indifferent to a prospect as large as the 1988 attorney's fees, we do not know how many claims have been settled, or indeed how many violations have occurred that have produced anything more than nominal injury. It is clear, at least, that the lower courts are allowing colorable knock-and-announce suits to go forward, unimpeded by assertions of qualified immunity. As far as we know, civil liability is an effective deterrent here, as we have assumed it is in other contexts. Another development over the past half-century that deters civil rights violations is the increasing professionalism of police forces, including a new emphasis on internal police discipline. Even as long ago as 1980, we felt it proper to assume that unlawful police behavior would be dealt with appropriately by the authorities, but we now have increasing evidence that police forces across the United States take the constitutional rights of citizens seriously. There have been wide-ranging reforms in the education, training, and supervision of police officers. Numerous sources are now available to teach officers and their supervisors what is required of them under this court's cases, how to respect constitutional guarantees in various situations, and how to craft an effective regime for internal discipline. Moreover, modern police forces are staffed with professionals. It is not credible to assert that internal discipline, which can limit successful careers, will not have a deterrent effect. There is also evidence that the increasing use of various forms of citizen review can enhance police accountability. In sum, the social costs of applying the exclusionary rule to knock-and-announce violations are considerable. The incentive to such violations is minimal to begin with, and the extant deterrences against them are substantial, incomparably greater than other factors deterring warrantless entries when MAP was decided. Resort to the massive remedy of suppressing evidence of guilt is unjustified.